This is Barry Zalma on Insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about some more types of construction defects. Probably the most popular and the one that brings about the most lawsuits is water intrusion. Structures, whether residential or commercial, are expected to be watertight. The only water that should enter a structure is that which serves domestic water needs for baths, sinks, toilets, washing machines, dishwashers, and other water-using appliances. There are many ways that water can get into a home. Plumbing defects, insufficient overhang on a roof, wrong materials for the geographic location such as stucco in a wet climate, defective air conditioning, leaky windows, leaky doors, insufficient flashing, inferior quality of wood, defective repair of plumbing, defective installation of a shower pan, the wrong mix of concrete, defective engineering, design, surface water intrusion, and lack of waterproofing can all contribute to water intrusion in a structure. Plumbing defects can involve inadequate components or neglect to install necessary parts for proper functioning. Defects involving inadequate shower or bath installations can include the following. 1. Tile installed over water-resistant gypsum board, green board, instead of a mortar setting bed or a cementitious backer board. 2. Edge of the green board above tub or shower pan lip is a cut edge instead of a wrapped factor edge. 3. Joints and penetrations are not sealed with a coat of ceramic tile mastic prior to tile installation. 4. Insufficient gap between the base of green board and the tub or shower pan. And or 5. Neglecting to use a flexible sealant joint at the tile to tub or shower pan juncture. When a property owner knows of a defect in his or her property and fails to warn a guest of that defect, the property owner is liable for any injury suffered. In one case, the property owner knew that as a result of a plumbing problem, the slab foundation was raised where it had been dug out and replaced to repair the plumbing. The plaintiff tripped and fell over the defective floor remaining from the plumbing repair and was injured, and the property owner was found liable. Water supply lines that have inadequate or missing pressure relief or control valves are considered defective. Pipes must also be of adequate size to carry the expected volumes in a structure. In a Connecticut case involving plumbing defects, a water pipe burst in a rented office directly above computer equipment, destroying the equipment below. The tenant sued the landlord for the damage. The law is fairly well settled in Connecticut and other states that when a landlord maintains control of any portion of a rented building, the landlord owes the tenant the duty to take reasonable care to keep that portion reasonably safe. Property owners have a responsibility to their tenants for damages to property caused by defective plumbing. Reversing the trial court's grant of summary judgment, the Second Circuit Court of Appeal found sufficient evidence for liability of a property owner and reasoned, quote, the plaintiff, Prodigy, has produced evidence that the pipes in the building were over 30 years old and that 6 other similar leaks occurred in the building prior to the leak in question. An engineering report described the pipe from which the leak occurred as 1 inch in diameter. Prodigy has characterized the point from which the water leaked as pinhole size. The report issued by the maintenance staff after the leak indicates that roughly 1,000 gallons of water escaped from the leak prior to its discovery. Given the generally poor condition of the pipes throughout the building, which might suggest a need to check for leaks on a regular basis, we believe a jury could conclude that a reasonable inspection would have revealed the leak much earlier. Close quote. This is Prodigy Services versus South Bend, a 1995 decision of the Second Circuit. In Texas, when a plumbing system failed, it was concluded that the homeowner bought a completed home, ready for move-in. The evidence established that the home builders contracted with others to furnish and install plumbing systems in the home. The plumbing installers obtained plumbing supplies from supply houses and manufacturers. They could not, therefore, hold the builder responsible for the owner's actions. In Arizona, sellers are obligated to disclose the existence of defective plumbing as a latent defect known to the seller in any purchase transaction, even if there is an as-is clause in the purchase agreement. In Louisiana, the 5-year warranty period applicable to major structural defects under the state's New Home Warranty Act applied to purchasers' claim against the builder, instead of the 2-year warranty period for plumbing defects, given that the alleged defect was the failing foundation, which was a major structural defect, and the plumbing repairs were a consequence or resulting damages from that defect. Liability for defective plumbing is not unlimited. In a case brought under the Racketeer-Influenced and Corrupt Organizations, the Ricoh Law, the plaintiffs owned properties in which polybutylene plumbing systems were installed. In the 1970s, Shell Oil Company purchased the exclusive right to sell polybutylene in the U.S. for a 10-year period. Shell then sold the PB resin pellets to pipe extruders, such as Vanguard and Bow, who made tubing from the pellets. The plaintiffs contended that the defendants manufactured and marketed these systems and components through a complex scheme to defraud. They alleged that the defendants made knowingly false claims in marketing PB, including assertions that 1, it is suitable for use as a hot and cold potable water plumbing system, 2, it will last 50 years, 3, it will not corrode, 4, it is easy, reliable, simple, proven, and fast, and 5, it will not occasion serious service problems. The Fifth Circuit refused to apply Ricoh to the complaint regardless of the defective nature of the polybutylene and concluded, quote, in sum, when civil Ricoh damages are sought for injuries resulting from fraud, a general requirement of reliance by the plaintiff is a common-sense liability limitation. To hold otherwise would allow the threat of treble damages and attorney fees to infiltrate garden variety products liability cases. Whenever marketing promotions touted the merits of the products, even if no plaintiff relied on those representations, this is not a statement of our policy choice. We are not persuaded by its by reason of phrase. Congress intended such a federalization and escalation of the state's law of product liability, laws that have hardly been proved to be anemic in their common law use of economic incentives to achieve desired social goals. The threshold reliance requirement is determinative in this case. We do not and need not reach other issues raised by the defendants." Close quote. The plaintiffs in this case were unsatisfied with the compensatory damages and attempted to get treble damages under a penalty statute. The penalty statute will allow treble damages in cases of fraud. The plaintiffs, however, did not have a direct relationship with the supplier and could not prove all of the elements of fraud needed for additional damages. The final decision did not prevent the plaintiffs from bringing an action against the manufacturers, distributors, and installers for their actual damages. Damages for leaking and defective polybutylene pipes were allowed when damage was shown. This is Zamora versus Shell Oil, a 1997 case from the California Court of Appeal. Roof defects can be caused by neglecting to install moisture barriers at roof lines and/or neglecting to install adequate flashing at roof lines, doors, windows, or other openings to the structure. When evidence establishes that the defective condition of a roof has been caused by a builder's faulty construction, the owner is entitled to damages regardless of when the defect first appeared. When a jury returns a verdict for the owner, and the court's review of the record convinces it that substantial evidence supports the jury's verdict, it will invariably affirm the decision. Courts are loath to overturn a factual finding of a jury and will only do so if there is no credible evidence that supports the jury's decision. When roofing does not perform as expected, the following causes of action are available to a property owner: strict tort liability for defects in the roofing products, strict tort liability for the faulty design of the roofing system, strict tort liability for public misrepresentations regarding roofing products, fraudulent misrepresentation, negligent misrepresentation, negligent performance of an undertaking to render services, breach of express and implied warranties, breach of contract, and failure to disclose. The causes of action that I've just read do not guarantee that a plaintiff will succeed, even when it is proven the roofing is defective. A lawsuit only provides the person filing suit the opportunity to prove that there was a defect in the product, that the defect was caused by people named as a defendant, and that the plaintiff was damaged. For example, the Third Circuit Court of Appeal held, quote, "The record establishes that the roof purchased by Jones and Laughlin was unsuitable for the weather conditions to which it was subject. The unsuitability or the failure of the roof to perform as anticipated by the parties does not give rise to a cause of action based on Illinois tort law. While it would appear that Jones and Laughlin did have a colorable breach of warranty claim under the UCC, the Uniform Commercial Code, assuming arguendo that the contract involved the sale of goods, the company did not file such a claim within the time limits specified by the Illinois Statute of Limitations." This is Jones and Laughlin Steel versus John Mansfield, a 1980 decision of the Third Circuit. In one case, massive roof leaks were discovered after the completion of a high school. The leaks were the result of splits in the roofing membrane and caused extensive damage to the interior of the building. After it became apparent that partial or limited repairs were inadequate to correct the leakage problem, it was determined that the Celotex bond ply membrane system would be replaced with a conventional 4-ply system. The owner of the property then sued unsuccessfully for the cost of replacement, interior property damage, and interruptions within the building during its use. The plaintiff's case did not succeed because the plaintiff failed to carry the burden of proof to establish that the roof or roofing materials were defective. Just because a new roof leaks does not mean that it is, by definition, defective. Property owners suing for defective products must be capable of proving the defect or be prepared for their suit to fail. Most manufacturer warranties require roofs to be free of ponding water 48 hours after a rainfall. Building codes in most jurisdictions require a roof drain, an overflow drain, scuppers or openings through the wall at every low point of the roof to draw water off the premises. Failure to fulfill building code requirements establishes a claim for insufficient drainage. Even if there's no specific code or custom practice, the reasonable expectations of a building owner can result in a cause of action. The drains must be 3 times the size of the roof drain and have an inlet line located a maximum of 2 inches above the adjacent roof point. Inadequate roofing or tiling defect claims can be caused by at least one or more of the following: a ridge of a tile roof left open to rain, leaks caused by open head walls, insufficient flashing or counter-flashing, neglecting to install flexible flashing with roof penetrations. Flashing has to be flexible enough to be lapped into the tile assembly, inadequate eaves that do not shed water, insufficient roof slope, insufficient drainage, use of appropriate materials for climates such as shake or shingle wood roofs in dry, high fire risk areas, insufficient cant strips, that's C-A-N-T, cant strips, and or neglecting to install proper coping to reduce the potential for water intrusion and eliminate most staining from top-of-wall runoff. Note that stucco cap parapet walls require a higher level of care in design and construction because stucco does not prevent water intrusion. This video was adapted from my book, Construction Defect and Insurance, Volume 2, which is available as both a Kindle book and as a paperback and part of an 8-volume text on construction defects and insurance from Amazon.com. If you found this video to be useful to you or of interest to your colleagues, please refer it on. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can be informed of future videos and future blog postings. Thank you for your attention.